have been a corporate lawyer for the last 12 years, and my main area of expertise is anything related to corporate law, which can be merger acquisition, arbitration, dispute resolution, documentation, share purchase agreement, share transfer agreement, funding documentation, everything. So that is my main expertise. And I have been working for past 12 years in India as well as in UAE. And while going through, what my experience has told me that uh, when the documentation is not done properly, whenever a fund is raised or during seed funding, then the after effects of that is very huge when there's a dispute. So founders tend to ignore these kind of documentation formalities at the time of raising funds, and the investors would be knowing much more than the founders regarding all these clauses, which eventually will affect the founders more because of their unawareness. For example, the founder might be more interested in raising of funds rather than no, reading through the documents which they might be negotiating or no, discussing. For example, the first process for a fundraising is drafting of term sheet. Term sheet is a small 5-page, 2-page term sheet where all the terms decided by the parties that has to be listed out. Unfortunately, at that time, the founders, due to their shortage of funds or in need of funds, they tend to ignore that aspect, and they tend to agree to all kind of clauses or all kind of restrictions put upon by the investors or the VCs, and they sign the term sheet. And based on this term sheet, the main master documentation or the share purchase agreement, share allotment agreement is drafted. So at that time, the founders would tend to get no get advice from legal lawyers or legal counsel. Even that is fine, because at that time we can at least stop the founders from entering into a one-sided agreement. But sometimes the founders do not even approach a legal counsel. Then what happens is the whole agreement is one-sided. So they would not have any rights, or their rights and powers would be restricted. And then when there's a dispute, when they go to the court goes to the documents and no goes against the founders. So here now I'll be sharing this screen so that we can have much better view about the presentation. Yeah. So my presentation would be about the things you should keep in mind while raising funds, or no, simple things. I'm not going into too much complication. These are the simple things or the basic things which a founder should keep in mind while approaching fund for funding or VCs. The four basic areas where they should always keep their mind, where they should always keep in mind are equity and valuation, control of the company, IP ownership, then funding and exit strategy. These areas will go in detail, and I will tell you the examples which I had where the founders had a lot of trouble because of because of their unawareness of this issue. I'll expand it. Yeah. The first one is equity and valuation. So always remember, the investors would always try to reduce the valuation, and the founders would always try to increase the valuation, which you might know. So what we have to ensure is have a proper valuation technique where the valuation is no, large as much as possible. Go to a proper no, proper accountant, chartered accountant, and get a proper valuation so that there is no dispute regarding the valuation of the company in future. Uh, the uh, the key terms which the founders should be aware of is the liquidation preference, anti-dilution provisions, voting rights, and board composition, which we will go in detail in next slides. Then there are other clauses which can also protect the founders their interest. We call it that no, there are a single trigger acceleration where a single event will have consequences which will be of the benefit of founders. We'll go in detail. And also then the investors might try to insert clauses which are overtly restrictive clauses for the founders, which has to be also no, the founders should be aware of it. Now, the first basic advice which we would give to the founders is there are two kinds of founders: one who is very active in the operations of the company, and one who might not be that much active or completely inactive in the operations of the company. So what we would suggest is, before going to raise the funds, it would be advisable for the founders, the active founders, to have the majority stock, majority share, and inactive founders to have lesser number of shares. Because when you go for funding, the investors tend to have more liking towards companies where the active investors have a larger chunk of shares, because then they have more trust towards the company, and then they have more belief that he will manage the company. In one of our cases, it was no, CS Sport case, CS Sport uh, company. In that, what happened is, the active founder held 20% of shares, and there were several other small shareholders which tend to accumulate together for around 80% of shares. So when they went for fundraising, the first question these investors asked is, why you are holding only 20% of shares, and how can we trust in investing this company when the smaller shareholders or inactive shareholders are not active in the participation of the company. So they could not get investment because of this sole reason. Even they could not go beyond the discussion stage because of this sole reason. So that we have to always keep in mind, active founders should hold majority shares. And when you go for investment, what percentage of shares is ideal for founders to hold? So ideally, I would suggest the founders should have at least 75 percentage of shares in the company after raising the funds, because all majority decisions will be taken only by the founders, or rather, the investors cannot take any major decisions without the founders' approval. But the world is not that perfect always. So I would suggest, if the second option would be around 50 percentage above, that should be the founders shares in the company after the fund is raised. Because in that then also the majority of decisions need to have approval, like for any decisions to be taken in the general meeting, it needs to be approved or vote. The voting should also include the 50% shareholder, that is the founder. If that is also not possible, if the fundraising is so huge that the shares of the founders will come down to 30%, at that time the documentation should be really taken care of. There should be rights attributed to the founder, and which will go in the next slides. So this has to be kept in mind. For example, I'll tell you, there was one hospital where there was two one was founding members, there was one group, and one was investors members. So what happened is, these founding members wanted to raise fund, and they got the fund from an investor. The investor held 51% of shares, and the founders held 49% of shares. So what happened is, all major decisions were taken by these investors, and founders could not deny it or veto it in many cases. So which really affected the rights of the founders over the company, because in general meeting they would come and vote against the decisions of the founders, and it really affected the company. So then we had to get in and show, as lawyers, we advise them how to get out of it, how to protect your interest as per company law, and then we could protect the founders as much as we could. Then another thing is that sometimes investors would come in, not by bringing in the money. They would say, I will provide certain services in in exchange for shares. So for example, there was a newspaper company, this is a big newspaper company, and they were investing in small startups by saying that they will provide the advertising services for the company. For example, I had a new tea powder. Mike, I am a startup, I am a founder. I had a new tea powder, and I wanted to raise capital. But this newspaper company came to me and said, we would not invest in your company for cash, but we will provide advertisement for next 2 years in such ways, in exchange for 30% or 40% of shares. So they agreed to it. So what happened is, uh, the capital did not come in, but the advertising uh, the advertising was done by the newspaper, but the response for the advertisement was not that great. So the sales of the tea powder did not increase as much as they thought. So what happened is, now the newspaper has 30% of shares. They did not invest any money, but the services they provide was not up to the standard, which affected the company, and they had a lot of issues in future. So that has to be kept in mind. As much as possible, get the money, or at least get the money. Along with that, there can be a club with services which the investors provide. Then this is very important. This is very important to have control and board composition in the company. The founders should always ensure they have significant representation in the board of directors. They should ideally it should be balanced board where founders has their members, investors has their members, and they can be independent directors. So what happens is most of the decisions is made in board meetings, not in general meeting, not in annual meeting, in board meeting. So one of our client, he was into aluminum fabrication, and he that client invested in another hospital where he held around 80% of shares. But in the board, there were five board members. Out of that five, only he was the board of director from his side. Rest all four were investors director. I know he didn't give it much a thought. He thought he held 80% of shares, so nothing can be done. So what happened is there was a dispute, and whenever a decision had to be taken in the board, the other four guys won't come. So only he would attend the board meeting, and because of lack of quorum, that is minimum two directors should be attending the meeting. Because of that reason, every time the meeting used to get cancelled. So that was an issue. If he had put in thought, he out of five board of directors, at least three should be in his favor. He should nominate the three directors, but that didn't happen, and it affected the running of the hospital. And then it had to the dispute went to general meeting. Then we had to resolve it by adding additional directors and all. So it was a tough decision. It was a tough process, because even though you hold 80% of shares, but you don't have any power over the board. So that has to be kept in mind for the founders. Always have a significant members in the board. Voting rights. Sometimes the investors would offer preference shares to the founders instead of equity shares while raising funds, which should not be the priority, because preference shares do not have any voting rights. Only equity has a voting rights. So that as much as possible should be avoided. Whatever rights we have, it should be in equity. What happens? So sometimes after funding, the founders right a founder's share would be very minuscule, or minuscule in the sense 20%, 30%. At that time, they don't have as much shares to take big decisions. So what happens is, in the agreement itself, in the investment agreement or share allotment of shareholders agreement, there should be rights allotted to the founders, that such decision cannot be taken without the approval of the founders. Amendment of articles cannot be taken by without the approval of founders. Further issue of shares cannot be taken without the approval of founders. So all these has to be in detail in the document. And what happens and the operation. So I will tell you an example. The investors somehow insist. I have a company, and it's a restaurant company. The investor insists that the finance guy will handle the check signatory or banking transactions, and the founder will not have any right over it. Sometimes founders tend to overlook this. So what happens is, if there's a purchase or payment to be made to the vendors, this the founder has to first approach the finance guy. The finance guy has to approach the investors, get their approval. Only then the signatory or payment will be released, which will affect the operations and the vendors, suppliers, everybody. So always ensure that the founders has the operational hold over the company, finance hold over the company, because if for every payment they have to get the approval of investors or other parties, that will be very difficult in the operation. Then the same goes to same thing here also is the same thing. There should be if they can have ESOPs or stock vesting schedules for the founders, in case they are terminated, their role is terminated in the company. That can also be mentioned in the agreement. Regarding IP ownership, that is intellectual ownership. So ideally, what I would say is the IP can be owned by the founders in the personal name, and then they can assign that right to the company. So in that case, if tomorrow the investors take over the company, they can just terminate the IP assignment, and the IP will be owned by the founders. So some investors do not allow that. They would ask the IP to be transferred or to be registered in the name of the company. But if it is possible, the intellectual property should be managed in such a manner where the founders has significant say over it. Because if it's a software company and the source code is not in the company's name, or is asked to be transferred to any other company which investors holds, then the founders will have a lot of trouble. So as much as possible, you can put it that the IP, the source code ownership is in the individual's name, founder's name, and they can assign it the license to use it to the company so that it remains with the founder. Now, regarding the funding and exit strategy. So, what is exit strategy? So, all investors need some exit strategy. That is, they will invest today, and tomorrow, when the valuation is more, they will exit from the company. So this is very important criteria for investors, because they don't have too much involvement in the operations of the company. They just want to invest and exit with profit. So we always advise founders to have staggered funding, Series A, Series B, Series C, so that if it doesn't come together, and it will have more trouble. So always it's better to have go slow. First, take a few investment, see how the investors function. Are they good? Then go for second series, then third series. So this would help the investors and founders to have better understanding of each other. It will help the company also. Also in the documentation, if tomorrow we got the fundings from the investors, and tomorrow we also need further investment. So what happens is, if documentation is not proper, the investors will sell their shares and to another investor, and then exit the company. And we would not know to whom the shares were sold, or rather we would come to know about it late. So we have to protect ourselves. We should know there should be specific clauses which protects the founders, that they should also be informed of such sale of shares of investor before they do it, or rather they should be offered for if investors tomorrow sell their shares, it has to be first offered to the founders. If the founders reject it, then only they can give it to outside third parties. So these clauses has to be mentioned in the agreement. So this is very important, because otherwise there'll be chances of hostile takeovers. As I said in the third point, another company would be trying to take over the company. So what happened is, in a charcoal company, they were packing the charcoals and they were selling it. So the business was going good. So they in this scenario, they got fund from an investor. Hmm. And they got the fund investor, but the agreement did not have any anti-dilution clause, which is that dilution of the shares of the founders. So if there's an anti-dilution clause, that in that clause it will be mentioned how much should be the minimum percentage of shares the founders should hold. If there's no anti-dilution clause, then what happens is, if tomorrow when the company requires more funds, more capital, the investor will bring in the capital, and their share percentage will increase, and the founders' share percentage will decrease. So in this case, when the first investor came, the founders held 80% of shares. Now, after investor came, they started raising more and more funds, because there was no specific provisions. So when more and more funds came in, the founders' shares got diluted. More funds came, diluted. Then what happened is, by it reached 20%, and then they lost control over the company, and then investors decided how to proceed, whether to sell it, whether to take over the company. So these things has to be kept in mind. Same with the anti-dilution process. This is the same thing which I said right now. So pro rata rights. So whenever investors have shares in the company, it is always important that the founders should have similar rights over the company. If investors tend to, so there are two kind of rights. There's drag along rights and tag along rights. So what is drag along rights? Drag along rights is, there's a founder, there's an investor. Tomorrow, the investor plans to sell their shares, and there is a drag along rights in the agreement, shareholders agreement. Then investor can drag the founder to sell their shares also. Suppose a third party wants to have the complete 100% of shares in the company. Because of existence of drag along rights in the agreement, this investor can drag the founder into selling their shares. So that is very bad for the founders, because even though they are not ready, they can be dragged along. Sometimes the founders are, if there's not drag along rights and there's only tag along rights, that's a clause. So what happens is, if a company is planning to sell their shares, these founders can also hop in or tag along with the founders and sell their shares also. So these are the small points which has to be kept in mind while handling this kind of funding strategies or exit strategies. Yeah, I think these things has to be kept in mind while raising funds. And if there are any further doubts, you can contact me at this number or website. I'll be happy to clarify it.
Thank you so much, Abid. Actually, like you mentioned, five different main topics, and giving really important details, sharing important details with us. Thank you so much about it. One thing that I want to ask you about your own experience, actually, although you mentioned very different legal pitfalls that startups often encountered when dealing with investors. So can you share one specific example, if you have any, that legal document saved the startup, or maybe you heard this story after it it caused the
Yeah, yeah.
failure? Yeah.
So there's something known as right to raw for rights or raw for rights. So that is, as I said, that sometimes what happens is even the investors tend to ignore some clauses of the agreement. So what happens is the business is going well, founder is handling everything. The investor want to sell the shares of the company. So they are going to sell the shares of their shares to third party. So the founders come to know that these guys are going to sell the shares. We don't want any third party to come in because the business is going good. So we don't want to give no and let the third party enter into the company. So what can be done? So we checked their agreement, shareholders agreement, and we see right of first refusal clause. That is, if any party, in this case investors tend want to sell their shares, it has to be mandatorily offered to the founders first, and a 30 days period has to be given, wherein if the founders refuse it, then only these investors can sell it to third party. So they did not abide by this. So we invoked in the court of law, we invoked this clause, and the court said to first offer the shares to the this thing founders. So why they were not interested in selling it to founders is that to the third party they were being sold at a very high premium. So what founders did, that they got an accountant and had a proper valuation. At that valuation, they were ready to buy it. So we because of this clause was there, we could prevent maybe a probable hostile takeover of the company, because it was really going good. It's an IT company. It was an IT company, so it was going good. So yeah, so sometimes no, even investors tend to be overconfident in all this, and they ignore all these clauses. So at the, and if the founders were really no really aware of all these clauses in the beginning, we could have given more protective clauses to them. Yeah, so there are certain such instances where we could help our clients in protecting themselves.
Yeah, actually, like you mentioned, thinking about the exit strategy and getting some legal documentation about it is really important for that as
Because
well.
especially in UAE, we had to know they only go through the documents. They don't want to hear the stories. They don't hear what is the pain. What is there in the document? They just ask what is there in the document. If the document says like this, they don't want to hear too much stories. Okay, if he had to be offered first, offer him and take it over. That's it. Have you the simple question they will ask? Have you offered? He said no, but no, but offer him, then come to me. So it's very easy. So so in that case, there's two things. One good thing is that documentation has to be proper. But if document is not proper, it can reverse to you. The founders will lose everything. They won't have any rights. The financial rights they won't have. For example, sometimes they have when the dispute arises, all this comes out. So as I said, the signatory, the banking signatory or check signatory must be with the investors. But the payment to the vendors is not happening because the investors are not releasing the fund. So the founders want the investors' approval, but they can't get it. So they go to court asking for permission. Court will go through the document and say you don't have any rights over it, so leave it. So it has to be kept in mind.
Thank you. Ronnie shared some questions that he gets from members previously. I want to ask one of them actually.
Mhm.
What is the best way and process to give employee shares, specifically founding members?
Founding members. So that is known as ESOP, employee stock option.
Mhm.
So can be given on vesting period will be there. That is, an agreement will be executed at the beginning, but the vesting period, that is after 1 year, such number of shares will be released in the name of the employee. After 2 years, so many numbers. So that vesting has to be discussed between the employee and the founder, and this has to be discussed and finalized. The vesting period, how much shares has to be given, and when he can sell these shares. It can't be like first year he worked and immediately he can sell. No, there has to be a period which has to be mentioned in the agreement.
Cool. Thank you. Thank you so much, Abid, for sharing your invaluable insights with us today. Your
I
expertise
really
in
appreciate it.
this area really help us. And for everyone in the community, remember that you can always reach out to Abid inside our community via direct messaging or however you like, so that you can get more knowledge about legal documentation and other stuff as well. And thank you for joining us today. Wish to see you
Thank you,
soon
Sari. Thank
again
you.
and
Thank you for
talk
giving
about
this
more.
opportunity.